សូមអញ្ជើញអង្គុយ
President, please be seated.
អង្គជំនុំជម្រះ
The court is back in session. And the chamber would like to give the floor to the defense team for Mr. Kilsompon to submit the arguments.
Merci, Monsieur le Président.
Thank you, Mr. President. The supposed responsibility of Mr. Kilsompon is obviously, as in all criminal proceedings, at the very center of the judgment. It is in the course of the examination of such responsibility that we realize to what extent the construction of that judgment was aimed at his conviction, and that is where we see how biased the approach was. And at this point in time, as I have to provide some explanations, as I did at the beginning of the appeals, why we drafted our brief the way we did it. It was important to decipher the process whereby the chamber had arrived at a conviction and what were the different acts it carried out throughout its analysis and reflection to arrive at the conviction of Mr. Kilsompon. And that is why we started with part 16 of the judgment in order to place the facts in a chronological manner in order to assess at what time the chamber found that such and such an intent or criminal intent was on what it was based. And that is why we drafted our brief in that manner. So quite obviously, it is not in 15 minutes that we'll be able to deal with all the errors of the chamber in a comprehensive manner. We have done this in our appeal brief. Today, I will focus on the legal errors committed by the chamber, and I'll try to answer the questions you've put to us by responding to some of the arguments raised by the co-prosecutors. First of all, the first point I referred to somewhat when I dealt with crimes, and which I would like to reiterate here. It is important, and it is the issue of accessibility and foreseeability of modes of responsibility, and it is paragraphs 68 to 98 of our appeal brief. Kilsompon could not have envisaged the sophisticated modes of responsibility of customary international law in 1975. Even though the modes of responsibility are envisaged in customary international law, and today we continue to raise questions. Today, Mr. Kilsompon is in Cambodia. The only system he knew when he was in the Maquis, as he spent most of his time dealing with that system, was the dualist legal system in Cambodia, and you cannot apply international norms to the Cambodian domestic law. That we should bear in mind. In 1975, it is obvious that he was not in a position to envisage what was a joint criminal enterprise. I have cited the jurisprudence of the ICC, and we should recall that when we talk of a joint criminal enterprise, we can only say that this was developed by the international criminal tribunals. To respond to the co-prosecutor's argument, this is what the prosecutor said. The prosecutor contends himself in saying that the gravity of the crimes supposed the criminal conduct of the appellant. That is not how we conceive the matter. I refer you to paragraph 46. The prosecutors know that they are wrong because they deliberately omitted to present the entirety of your reasoning in your appeals judgment or decision. And we should recall, before we look more closely at what you said in that decision, the criminal conduct of an accused person is a combination of both the actus reus and the mens rea. The principle of legality applies to both constituent elements, and you cannot consider only one of them. And the principle of legality applies to the modes of participation as well, and not only to the crime. In paragraph 96 of the Deutsch appeals judgment, you also cite the Azilanovic decision regarding credibility, and you said that some laws can be considered as having been accessible to the accused, and you continue to say, still in paragraph 96, that a chamber can rely on domestic law to establish that an accused could have reasonably known that the crime, as described in the indictment, was foreseeable, and that is precisely our argument. But you do not stop there, since you hold that there is an obligation to verify the elements that constitute the crimes and modes of participation. I refer you to paragraph 97 of the Deutsch appeals judgment, in which you state that the ECCC, based on the principle of legality and the principles attached to it, to ascertain that the criteria that define the elements of crimes as well as the modes of participation retained were envisaged in the law during the period that fell within the temporary jurisdiction of the court. They should have been foreseeable and should have been accessible. These are the principles you lay down in that appeals judgment, and you underscored still in paragraph 97 that a very careful and rational assessment of the criteria is indispensable to guarantee the legitimacy of the ECCC and the decisions it renders. In light of what you stated, the response of the co-prosecutors to support the position of the chamber is very far from convincing. I refer you to our submissions on joint criminal enterprise in paragraphs 68 to 73 of our appeal brief. But before we deal with the question that you asked regarding joint criminal enterprise as it should have existed in 1975, it is important, nevertheless, to recall that in the interpretation of the chamber of what the joint criminal enterprise one is, there is a fundamental error in it, because it applies the mens rea applicable to JCE 3. The chamber erred egregiously in its definition of the mens rea for JCE 1. It tried to legitimate that error by using an extensive interpretation of the actus reus, and I refer you to paragraphs 694 to 696 of the judgment. The various requirements it relies on to arrive at its position did not exist anymore during the period in question as today, and we'll see this clearly. In any case, that interpretation is false and cannot engage any form of responsibility for Mr. Kyosampan. Let us recall that the chamber, for a start, correctly recalls the actus reus. It starts by saying that there must be a common purpose which consists in committing a crime or which entails the commission thereof. And it is in line with the decision that was rendered on the 12th of November 2011, document E100/6, in which it applied JCE 3. The problem is that after recalling this correctly, it does what I would call a semantic slide towards common purpose, and says a common purpose can lead to the commission of a crime and can envisage the commission of and the means used to commit a crime. Paragraph 313 of the prosecutor's brief states that there is no difference, and yet the difference is important. This different formulation has a different meaning, and before we talk of the law, we have to look at the vocabulary, the terminology. There's a common plan that involves the participation in the crime, and I refer you to paragraph 692, which refers us to the Tajik appeals judgment, and here we find the right definition, and it says that a crime has to be committed as part of the common realization of the common purpose, and it is an integral part of the process. In the reverse, a common purpose which envisages the perpetration of a crime, that is paragraph 696, is a plan according to which it is possible to commit a crime. It is therefore not an integral part of it. So we find that in this different formulation, the chamber brought into the process something that doesn't exist in the actus reus in the commission of JCE1. And in so doing, it lowers the bar, it lowers the standard. And what we see in this different formulation is that the chamber tries to lower the bar in order to achieve a purpose. And I referred to this yesterday by talking of the distortion of evidence, the actus reus, and the mens rea of the crimes. We need these standards because we do not have enough indicia to reach a correct standard that allows us to rule that Mr. Kyo Sampan had the intent to commit such and such a crime. And this brings us, of course, to your question on the state of customary international law in 1975 as regards crimes that were uncertain and not, or crimes that were just probable. The question was formulated as follows. You asked whether in the application of customary international law as it was in 1975, individual criminal responsibility based on the joint criminal enterprise in its basic form, whether or not it existed at the time, would necessarily have called for a situation in which the author would try to seek to commit the crime in question as part of the implementation of a common purpose, in the sense that the commission of a crime was the common objective, or whether it encompassed also situations in which the author knew that the crimes in question would be or could be committed as part of the implementation of the common purpose. Before I elaborate on this, perhaps I need to slow down.
Je vais essayer de ralentir, Monsieur le Président.
I will try to slow down, Mr. President. I didn't hear the translation of what you said.
Je suppose que c'est un trait à la vitesse de mon débit.
I suppose that it has to do with my speed, so I'll try to slow down. Before I elaborate further and review the case law that existed at the time, I will respond to avoid the suspense that the answer is clear. There is no room for uncertain crimes. The crimes in question must be part of a common purpose, and the perpetrator of that crime should have the intent to commit that specific crime. The perpetrator must have the intent to commit a crime as part of the implementation of the common purpose. And when we look at the case law of the International Military Tribunal, that is the Nuremberg trial, we find that the case law doesn't tell us anything different from that. I will not go into doctrinal discussions because there have been many on the terminology of joint criminal enterprise, and that didn't exist between the international criminal tribunals. It was only conceived of subsequently. An analogy was drawn between JCE 1, I'll use the English term, conspiracy, and it is very close to what we refer to today as joint criminal enterprise. I will not go into doctrinal discussions. I will refer to Milu Dinojic, and there was an analogy in which they tried to prove that it was not the same thing, but there are similarities nevertheless. On this basis, all the more so as I can recall the Nuremberg decision, in which in the indictment we're still referring to the English. Similarly, we find this in the works of the International Law Commission of 1996. I still refer to it in English.
Responsibility for formulating a plan or participating in a common plan or conspiracy to commit a crime. Fin de citation.
End of quote. And what we submit before this chamber is that it is impossible to draw any arguments from the case law of the Nuremberg trials to say that even within the same, within the framework of the same conspiracy, there's a standard envisaged in the joint criminal enterprise as determined and defined in Tadic. Neither the trial chamber nor the co-prosecutors can reasonably argue that in light of the Nuremberg case law before 1975 and in 1975, international customer international law envisaged a standard that was lower than the possibility of committing the crime. It cites many cases, the Einsatzgruppen case, the Schoenfeld case, and the Paul case. It is therefore important to recall that in most cases we don't necessarily have the judgments in their entirety. A large proportion of these case law were cited profusely in the Tadic appeals judgments, so I crave your indulgence for the manner in which I'll cite them, because I'll focus particularly on excerpts of the Tadic judgments and translations thereof. It is important to proceed in a chronological manner and say that there is some continuity in this case law. First of all, outside of what the co-prosecutors have said, in the Sandrock case and in Analo case in November 45, we have 3 cases of persons found guilty by British tribunals. We are talking of war crimes, and these cases are an essential source for us. In that case, the assessor recalls it was beyond doubt to my mind that the 3 Germans knew what they were doing and had gone to a particular location solely to kill the officer. You know that they were aware that they were committing joint criminal enterprise. We realize that we are in a joint criminal enterprise, as is stated in that excerpt. And there were persons present, and they were participating in that joint criminal enterprise, which was illicit, and the purpose was illegal, to kill someone. The crime should therefore be planned. It should not be a crime that is only possible and likely. There is a plan with a criminal purpose In April 1946, we have the Holzer et al. Case. In this case, it is a Canadian military court, and the assessor is talking of a criminal enterprise regarding the murder of a Canadian prisoner of war by 3 Germans. And it goes that the 3 persons knew that they were taking the victim to a precise location with a view to killing him. Now we are talking of a criminal enterprise. And all the persons in that enterprise had a purpose which was criminal. In August 1946, we have the Jospin et al. Case. Here again, we find that this is quoted in Tadic, and I quote, "If Jepson participated in this deliberate massacre of some 80 persons, aiding the others to do their share of the dirty work, all of the 80 murders could be attributed to him, as well as to all the others who, in one way or the other, aided the commission of that offense." We can talk of complicity here, but in this case, we are talking of active participation in a plan with a view to committing a criminal act per se. There is no doubt here that there is a crime that is certainly going to be committed, and it was to go and commit a murder. Let us analyze the case law as quoted by the co-prosecutors. In any case, we have here, June 1946, the Schoenfeld case. We have an extract of this case law, an extract of the report on that case. And this is the extract they intend to use, that is the co-prosecutors intend to use. And it states as follows, and I quote, "If several persons come together to commit an illegal purpose or to carry out an illegal purpose with a view to having recourse to illegal means to kill someone, that murder can be attributed to all the persons present when the offense was being committed, knowing that they were going to participate in the commission of the group, of the murder." End of quote, free translation. For the judges to reach a finding that the joint criminal enterprise was committed, when we look at the documents presented by the co-prosecutors, we find that what is quoted here is a provision of English law, and a provision is established by a judge advocate. I don't know how tribunals of the time function. We know that the assessor is a prosecutor who gives advice to the court. We don't have any reasoning of the judgment, so to say that this is case law will be going too far. We do not have any written judgment. We only have the findings of the parties or the submissions of the parties on the subject, even though we do not know the exact reasoning of the court in question. What is important to note is that a little later, other explanations are furnished when I state that there is no exact trace of the reasoning of the chamber. It is stated in the document as follows.
Its reason for deciding as it did. Excusez-moi. Et là, c'est le
court's indulgence. We're talking of Law Reports, volume 11, page 71. So we cannot state that we have a certain judgment on this point, but we should also recall the circumstances at the time. In the Schoenfeld case, the judges raised questions on the complicity of members of a military unit who participated in an arrest, and they wanted to find out whether they were present at the time when a certain Rotschov executed illegally 3 persons. So we are no longer in the area of complicity. We are, are we in a joint criminal enterprise? And I continue by saying that the same judge advocate who cited the provisions of English law And these are the provisions that the co-prosecutors would like to use. The judge advocate says something later on, and I quote in English.
Excusez-moi, j'ai oublié de prévenir que je parlais en anglais. If the court takes the view that the object of the visit to the Diepenstraat 49 was in its origin lawful, that is to say, to effect arrests, and was being carried out by lawful means, but that in the course of its prosecution, Rotrop kills the 3 men, but that the others did not aid or abet such killing, then, no doubt, the court would find them not guilty of the charge of being concerned in the killing. Fin de citation.
End of quote. So here, if we consider the question of complicity or common purpose in any case, the issue such as summarized by the same judge advocate who recalled the English military legal standard, when he sums up the problem, he clearly says that there has to be a participation and involvement in a purpose that is criminal in itself. And the jurisprudence that follows supports this analysis, and I'd like to refer you to the Renzano case in August 1948, which is also quoted in the Tadich appeal judgment, and it is important, or it is necessary for an accused person before being convicted has been involved in the crime. Being involved in the commission of a crime does not signify only that the person is a person who caused the death of the victim, whether it be through a gunshot or any violent mean, but also supposes a degree of indirect participation. In other words, he must be the cog in a succession of events that led to the result that happens. He can reach these means not only by giving the order to commit a crime, but also through various other means. The question here that is raised is not if this is a crime that is improbable or uncertain. The question is this direct or indirect participation? And however, the knowledge of the purpose must be that it is clear that the purpose is a crime. It was necessary for the accused person to be aware of the criminal purpose, the criminal part of the joint criminal enterprise. And when I speak about the criminal part of the joint criminal enterprise, I mean that it is necessary to remind that in this particular case here, the co-investigating judges and the chamber retained the fact that creating a socialist regime in democratic Cambodia was not in itself a criminal purpose, but that policies resulted from this that then led to the commission of crimes. And what we always said in the Kyosampan defense team, when defending our climate, what we always said, whether it be before the chamber or whether it be in our written submissions, was that never the chamber provides the evidence that Kyosampan cooperated at one point in time with the Democratic Kampuchea regime with the purpose of committing a crime. There was a political project, but never the chamber said or determined what would be the criminal part of the common purpose and what would be the involvement and the significant contribution of Kyosampan to a criminal aspect of the common purpose. Now I would like to return to the jurisprudence from that time, the necessity of proving the knowledge of the criminal purpose. It is necessary to prove that when a person took part in the crime, the person knew the purpose. This is very important. A person is indeed involved when that person knows the purpose of his or her acts. Other jurisprudence, the Paul case, the 1948 trial of the WVHA. In this case, several defendants were convicted for crimes against humanity, and these were defendants who were in charge of running concentration camps. And it's interesting to note here that with regard to each one of the defendants, and I'm not going to go into detail because I don't have much time, but in any case, with regard to each one of the defendants, the report states that they either played a role that had a direct connection with the commission of the crime, or they had a role that was a necessary element in the commission of the crimes. And for none of the defendants, the notion of anything else than the criminal purpose is considered. The same thing for another jurisprudence that the co-prosecutors wish to use, 1951, the Einsatzgruppen case. Here, once again, in the documents, it is clear that the necessity to be connected to the purpose of the crime. We're not speaking about any other purpose than the commission of the crimes, and this is what we can read, such as reminded in the Tadic appeal judgment. In fact, thus, not only the main perpetrators, but also the accomplices are guilty. Those who contributed in the commission of the crime or who are involved in a project that is linked to the commission of the crime, and those who belong to an organization or a group intending to commit such a crime. Here again, the purpose is clear. It is necessary for a crime to be considered. The crime has to be the purpose. And I'm not going to lose too much time here because I have quite a few things to bring up, but simply I'd like to tell you that what we retained, or what was retained, was that all of the members knew that the aim was to commit murder at a large scale. And this is the jurisprudence such as we understand it from the report. So here again, the common purpose in this current case here is not, and I'm not the one who said it, but it's the trial chamber and the co-investigating judges said this. The aim is, the common purpose in itself was not criminal in itself. This is what we said. And if the purpose is not criminal, we should not be told that he participated, or our defendant participated in the common purpose in a general purpose, which is not criminal in itself. But what we have to see is which significant contribution he provided for the commission of criminal acts. This is with regard to the answer to your question. Depending on the jurisprudence of the period, which corresponds essentially to the Nuremberg trial, there is no room for uncertain crimes. There is no room for possible crimes. And the question that I recalled this morning, and that I recalled at the beginning of my submission, the main question remains, that is to say, what was the accessibility and the foreseeability of this kind of mode of liability for Mr. Kyosampon? Once again, 1970, 1975, he was in the Maquis. And when he left the Maquis, Cambodia was devastated. So where could someone like Kyosampon could have found documents in order to interpret in an extensive way a mode of liability involving conspiracy such as what happened in Nuremberg, and on top of that with the idea of recklessness, which does not exist at all in the jurisprudence I just covered with you. And let's be clear about this. Neither the co-investigating judges, nor the pretrial chamber, nor the trial chamber, nor the prosecutors have raised this notion that might have existed in 1975. So, if more than 40 years after the facts, if more than 15 years after the Tadic case, you're the first ones to ask that question, well, it's not Mr. Kyosampon, I should tell you, who in the depths of his Maquis, who would have had the idea of thinking about such a mode of liability. So, we state once again that the chamber committed an error of law with regard to the mens rea by lowering the threshold to a lower degree, which is the awareness that crimes would probably be committed. And here I'm referring you to our appeal brief, paragraph 68 to 71. And I would like to remind you with regard to the basic form, the VOCA appeal judgment which the Chamber uses never states that it was the intent of participating that matters. It said, on the contrary, the intention of committing the common purpose, and that the jurisprudence is very clear about this. The Tadisha appeal case, paragraph 228. However, when we speak about basic joint criminal enterprise, the mens rea varies depending on the category that the common purpose falls under. Now, regarding the first category, the required element is the intent of committing a specific crime. This intent being shared, of course, by the co-perpetrators. The Vasily Devich appeal judgment, paragraph 101, the mens rea varies depending on the category of the joint criminal enterprise considered. Regarding the basic form, the required element is the intent to commit a specific crime. This purpose has to be shared by all of the co-perpetrators. And we can continue. The Stakic appeal judgment, for example, paragraph 65. The required mens rea to convict varies depending on the category of the considered JCE. Regarding the basic form, we have to prove that the accused person and the other participants in the JCE had the intent of committing a specific crime. The Sinovic appeal judgment, paragraph 996, and I will quote in English.
The trial chamber correctly articulated the requisite mens rea for the first category of JCE, explaining that it had proved that the accused shared with the other JCE members the intent to commit the crime of the underlying offense. Fin de citation.
End of quote. And I would like to add to this the Munyakazi appeal judgment, 28 September 2011, in English once again.
Of joint criminal enterprise, which is at issue in this case, requires that the accused must both intend the commission of the crime and intend to participate in a common plan aimed at its commission. Et c'est bien ce que je...
And this is what I was telling you at the beginning of my statement, the problem that the chamber, the trial chamber faced, and is that the chamber never determined that Kyusampon was driven by the intent of committing a specific crime, whether it be with regard to population movement 1, 2, or Tulpul Shrey. And this is why it is by violating the law in a complete violation of the constant jurisprudence that the chamber needed to use a concept of a lower threshold, which is the foreseeability of the crimes or the awareness that these crimes would probably be committed. And I would like to refer you to paragraph 944 of the judgment. So this criteria, which is illegally transposed from the JCE doctrine to this case, which Kong Samon will speak about more in detail, was not applicable. It could not be used as a substitute for the intent of committing a crime. And we'd like to refer you, with regard to this, to our developments in our appeal brief. And it is interesting also to note that, as I said to you, the issue of introducing the recurring modus operandi with all of the issues of the trial's jurisdiction was only focused on the idea that the possibility of the crime being committed with a lower mens rea. And with this lower mens rea, we had to find a few elements to find a link between Kyusampon and the crime, and therefore to convict him or to declare him liable. Now, I would like to, I see that my time is running out, and I must still answer the question about the recharacterization. And you asked us this morning, the co-prosecutor spoke about this morning, you asked for for a written response because you were thinking about recharacterizing the mode of liability for the crimes of extermination during population transfer 1, population transfer 2, and forced disappearance and persecution for political reasons at Tulpul Shrey. So I don't have much time, so I will refer you to our written submissions F30/5, but still I'd like to answer the observations F30/6 of the co-prosecutors. First of all, in order to recall our position, let me sum up our position that is stated in our submissions in view of the applicable law and the circumstances of the case. This is what we said. We said that you cannot proceed to such a recharacterization for three reasons. The first, this would mean introducing for the first time in appeal a new constitutive element which the Chamber has not ruled upon or was not called to rule upon. Indeed, JCE has different constitutive elements, in particular the actus reus, with the shared intent of committing a specific crime, which is more demanding regarding the modes of participation in the closing order. Here, it's not a question of degree of participation only. There are a certain number of specific elements that are not intrinsic to the original accusation, and I'd like to send you to our appeal brief, paragraphs 18 to 37. Second reason, you would aggravate, if you did this, Khieu Samphan's fate, who lodged an appeal.
Counsel, please slow down as the interpreter cannot catch up with your speed, and we grant you an additional 10 more minutes.
Thank you, Mr. President. Maybe this will allow me to be a bit more serene as I speak and to speak slower. Well, the second point that we raised in our written submissions is that the Supreme Court would aggravate Khieu Samphan's fate, who lodged an appeal, whereas the co-prosecutors did not appeal the judgment, they only appealed the decision on the application of JCE 3. And since they did not make this appeal, we would be in a situation where we would be violating the principle that you yourselves had recalled, that is to say, Rule 110/3 or -3 of the internal rules, that is to say, non-reformation peius, according to which an appeal should not revise the division at the detriment of the person who is appealing, putting the appellant in a position that's more disadvantageous before making the appeal. And this would be the case because there would be a new form of characterization regarding these crimes, a new characterization of liability that was not considered initially. And finally, third point, third obstacle according to us, the Supreme Court would violate Khieu Samphan's right to recourse because pursuant to rule, here I have a problem with mine as well, pursuant to a rule from the internal rules, you will determine Khieu Samphan's fate as a last resort, so there's no recourse. There's no recourse here following that new characterization, which is an ultimate decision in this case. So what do the co-prosecutors say when they answer? Document F30/6, the co-prosecutors are asking you to act in an illegal way. They start by recalling Rule 110.2, according to which the chamber can substitute the characterization of the trial chamber another characterization. However, it cannot introduce a new constitutive element for which the trial chamber was not called upon to rule. Let me please start again. So I would like to refer to Rule 110.2. The chamber indeed can substitute another characterization to the characterization chosen by the trial chamber. However, it cannot introduce a new constitutive element on which for which the trial chamber was not called upon to rule. And it recalls here, and I think they reminded, the co-prosecutors reminded this morning when they quote jurisprudence from the ICC, but none of this jurisprudence is relevant because none of this jurisprudence is based on a similar text. At the ECCC, the text is clear. The Supreme Court does not need to be guided by anything else than Rule 110-3 2. However, in the Cambodian, and in its counterpart in the Cambodian Criminal Code, which means that the Supreme Court cannot introduce a new constitutive element which the trial chamber was not called upon to rule on. And what the co-prosecutors are requesting from you is not even recharacterization. They're asking for an extension of this characterization. But recharacterization is not an extension. It is a substitution, a new characterization. So we're changing. We're replacing something here. We replace a characterization with another. And the confusion here of the prosecutors is blatant because in paragraph 14 of their response, they're asking you, and I will quote in English,
a characterization of GCA convictions. Si vous deviez, et ils vous le demandent en les étendant aux crimes qui n'avaient pas reçu cette qualité.
They're asking to extend this to the crimes that had not been characterized in such a way at the start. And this brings us back to, specifically, to the obstacle that we see, which is to say that since, and this is in paragraph 19, since the co-prosecutors acknowledge that the JCE has specific constitutive elements, and in particular,
to participate in the common purpose, et là,
and here, this is a poor explanation because we like to recall once again that the required intent is not to participate in the common purpose but to commit a specific crime. And Rule 110.2 formally forbids the Supreme Court from introducing new constitutive elements. So for us, there is a real obstacle here, a real problem. And in the Duke appeal judgment, because it is in this jurisprudence that the possibility of recharacterizing came up, the situation wasn't the same. There was a recharacterization by a chamber based on elements on which the trial chamber was led to rule. The trial chamber was led to rule on these elements. I'd like to refer you to paragraph 15 of our appeal brief. And you took care of respecting Rule 110.2 and Article 400 of the Cambodian Criminal Code. You specified that the accused had not been acquitted of his crimes before indicating that by convicting the accused, you were respecting Rule 110.2 of the Internal Rules and Article 401 of the Cambodian Code of Criminal Procedure. And here you quoted the rule. And here I'd like to refer you to the Duke Appeal Judgment F28, footnote 735. In the Duke case, once again, the trial chamber was called to rule upon the crimes in question. The idea here was not modes of responsibility or of liability, but in any case, if we look at the rest of the jurisprudence, for example, the Stakic appeal judgment in paragraph 58 of 104, which is quoted by the co-prosecutors to support their position, we are told that this is an example that you can use as a source of inspiration. But this is not at all the same case with the Stakic case, because the fundamental difference is that the trial chamber was called to rule upon the crimes in question. And this you can see when you look at paragraph 58 and 104 of this appeal judgment. It's very clear. The trial chamber ruled on that issue. And in this particular case, the trial chamber did not rule on the mode of liability, on these specific facts. They spoke about other facts, so therefore it's necessary, however, to recall that we had an investigation, investigating judges who made a choice, and the prosecutors had the possibility of asking for recharacterization at that moment, but they did not do so. No observations on the elements during the preliminary objections. The chamber itself never, in fact, invited the parties to recharacterize these issues. So now we're coming at the end of a whole procedure, and now the first time the question is raised before the Supreme Court, and we cannot deprive Kyosampan of a double degree of jurisdiction because he is the one who is appealing, and this would be putting him in a much more tenuous position than the position he enjoyed before appealing. Now, regarding the rest, because I only have a few minutes left, I'm going to cover this very quickly, and then I will, of course, be available for possible questions that you may put to me. But simply, I'd like to tell you that the issue of lowering the threshold regarding mens rea is the same for aiding and abetting, and it's the same for planning, and the same for encouraging. Regarding aiding and abetting, basically the mens rea is based on international custom. As the co-prosecutors say, they mention appeal judgments. We have to remember that the foreign Ziza appeal judgment mentions 3 kinds of mens rea: knowledge of the contribution, knowledge of or identity, absence of mens rea. And here we should recall once again that this is jurisprudence that it comes after the facts involved in this case. And I will finish here simply by telling you, because I haven't had the time to go into the factual elements, but simply like to quote an example or to mention an example to show you how the Chamber's argumentation, how the Chamber's constructs are full of errors. And do not correspond to any logical development. I'd like to refer you to paragraph 955 of the judgment, where we are told that the mode of liability with regard to JCE and with regard to the supposed knowledge of Que Sampan on the totality of the policies, paragraph 955, Que Sampan en tout projet. What does the Chamber say here? The Chamber says that, therefore, even if there is no evidence establishing that Que Sampan was aware of the specific nature of the crimes that were committed at Tulpultre, the trial chamber is convinced that he knew that there was back then a recurring modus operandi after the liberation of a zone to arrest, execute, and disappear the soldiers of the Khmer Republic. So in this paragraph, this is a clear demonstration of what I've been telling you since the beginning of these proceedings, that is to say, the factual errors, the errors with regard to the characterization of the crimes, and the errors with regard to the modes of participation have only one single objective, is to say that even if he did not know, even if he did not participate, even if there's no significant contribution on the part of our client, he has to be convicted despite, regardless of everything. And that is the core problem of the judgment.
President, thank you, Council, for your submissions. Let me have a short break. We have a short break now and return at 2:45.